Hi, in this latest immigration law update video, I want to look at a new case that talks about the Secretary of State's duty to disclose policies to the Tribunal and other documents which are unfavourable to her case. This is a case called BH brackets policies stroke information SOS's duties Iraq 2020 UK UT 189. That's a bit of a mouthful. It was a presidential panel and also the vice president was on the panel too. This was a case involving an Iraqi asylum seeker, and one of the issues was that it was a challenge to the upper tribunal on the basis that the Secretary of State had not put before the tribunal their latest CPIN, country policy and information note on Iraq. So the question before the tribunal was, what was the duty in respect of putting policies before the tribunal? Well, the head note says this, and as I go through the head note, I'll give a bit of an explanation. The first thing is the Secretary of State has a duty to reach decisions that are in accordance with her policies in the immigration field. Well, we know that from public law, that there's a duty on the Secretary of State to properly make decisions in accordance with her own policies. Not to do that would be a public law error. Cases like Lumba say that, cases like Mandela in the Supreme Court. Then they go on and say this: where there appears to be a policy that is not otherwise apparent and which may throw doubt on the Secretary of State's case before the tribunal, she is under a duty to make a relevant policy known to the tribunal. And note this, whether or not the policy is published and so available in the public domain. So if there's a policy that goes against the Secretary of State's case, whether or not it's a public policy, they need to disclose it to the tribunal. And they say, look, despite the fact that tribunal judges are experts, they're not to be expected to know every policy that the Secretary of State has. Then they say this: in protection appeals, and probably in other kinds of immigration appeals, the Secretary of State has a duty not to mislead, which requires her to draw attention to documents, etc., under her control or in the possession of another government department which are not in the public domain and which she knows or ought to know undermine or qualify her case. Now they look at a case called Karouche, I'm probably mispronouncing that, but it's a case from 1997 called Karouche, and this is about the duty of disclosure. So this is not just policies now, this is where they have information or documents in their possession which is not in the public domain. So documents which are policy have to be disclosed whether or not they're in the public domain. Documents which are not policy have to be disclosed if they're not in the public domain. If they're already in the public domain, they don't need to be disclosed. There's the differential. And they say this: there is a clear distinction between information and policy. The fact that country information is contained in a COI document published by the Secretary of State does not, without more, make that information subject to the duty in subparagraph A. That was the part about the duty to disclose policies. Because what they do is they look at a case called AUB Srilanka, and I'll put the link below this video, and say, look, there's a clear distinction between policy and just information. Policy, we can see, has to be disclosed. Information, if it's in the public domain, doesn't need to be disclosed. And they go back to this Iraqi country policy document and they say, well, this was effectively, all it was country information. In essence, there was no policy there in the document. So this was in the public domain. It didn't need to be disclosed. This is an important case when it comes to looking at appeals, particularly perhaps where we see the Secretary of State not citing relevant policies. And it may also be relevant when you look at judicial review cases in perhaps decisions which haven't got a right of appeal and the Secretary of State hasn't engaged with their own policies that undermine her case. So have a look at this decision, an important one. I hope that helps.